This webinar today is about writing samples and that you provide to firms when you're looking for a position. And let me make sure I'm sharing the screen. Perfect. I am. Great. Give me 1 second. Yeah. And so we'll start talking about that right now. Just a couple of things, just a little kind of housekeeping matters as we get started. Next week, we'll be doing a webinar about talking about the state of the legal market, which is one of my favorite webinars of the year. And we'll be going over the candidates that we got interviews for, not their names or anything, but different practice areas, and tell you what the market looks like going into this year. And that's actually a very popular webinar. So I hope you come to that one. And with that, I'll get started on this one. Also, one other thing I would like to say just as we get started is this is actually a very good week to start applying to jobs. If you're in the legal job market, or even if you're actively looking, or if you're just thinking about looking, this is a fairly slow week, but people do work this week. And even today and tomorrow, if you're able to get your applications in to places that have new openings, you have a very good chance of getting looked at, because not a lot of people are applying to jobs right now because this is a slow time of year. So anytime the market's a little bit slow and people are slow, it's always a good time to be applying to positions. So this webinar is about, we're talking about writing samples today. And writing samples are something that more often than not actually hurt people as opposed to helping them. A lot of law firms ask for them and never look at them because they're more eager to hire people. But the ones that do look at them, many times it can really hurt you in getting the positions. And there are people inside of every firm whose job is to kind of review writing samples, and they get their sense of authority many times from reviewing them. And they have the reputation of many times making a high percentage of people not get jobs because of the quality of the writing sample. This is just an example of an email I received from a firm not too long ago. It says, we're going to pass on this candidate. It was a tough call, though everyone loved the candidate, thought the person had experience were the best of everyone we've been interviewed so far. The writing sample had typos and fragmented sentences, and this reflected negatively on the candidate's attention to detail and their ability to proofread, skills essential to our practice. Please continue to search for us. And writing samples really do have the potential to sabotage your candidacy. Also, the way you write an email and so forth also has that potential. People are looking for you to make mistakes. And if you make mistakes, it can hurt you quite a bit. I had an instance once where I was about ready to receive an offer at a firm, and they discovered a date was off by a month on my resume. And the resume obviously is much different than a writing sample, but the date was off by a month, and it was something about graduation. I think when I graduated from law school, the graduation was in May and not June. And I put June, and I interviewed with someone that went to the school, and they said, well, he graduated in May, not June. And they actually thought that was a big deal. And I was just used to, as a matter of course, putting June down for those dates. People look at typos and stuff inside of law firms very seriously. And so a writing sample is this big, long document that gives you the opportunity to make a lot of mistakes. And so when you do turn in writing samples, you have to be very careful about what happens in terms of that writing sample. And I remember once getting a law review article accepted, and really the only thing I had to do was just to take a paper that I'd already written and spend a week or two just proofreading it. And so the more you proofread stuff, the better quality of work, and the more law review type work you can turn out. And you would be surprised at how important proofreading is. In many large law firms, which I think a lot of young attorneys don't learn about until they get much older, you may be able to write a brief in 20 or 30 hours, but the proofreading portion of fixing everything typically can take much more time than that. It could take many times weeks in terms of getting feedback and doing a good job. The quality of your writing, how tight it is, the absence of typos, the absence of words that have double meanings and so forth that are improper in the context they're in, is hugely important. And it's something that you need to make sure that you're doing a very good job with when you turn in work. And it also is something that can make you a very good attorney when you get good at it. And you typically will showcase what the quality of attorney you are based on your writing and how clear it is and how direct and so forth. So you need to be very careful with that. And a lot of people don't like writing samples, and it's for that reason, because there's so much thought that goes into doing very good writing. And just a frequent question that I receive, and I just wanted to answer it real briefly, is that when you're doing a writing sample, you don't necessarily need to worry so much about privilege. If you're writing something that's public, then you don't need to do a lot of redactions, meaning if it's something you file with court, and your name's on it and you signed it. If it's a memo or something along those lines, you typically do need to take out the client's name, but you don't need to go, into too much time. But the biggest thing is with that sort of information, the biggest thing you need to be concerned about is making sure that the writing sample is of good quality. And as I said earlier, most people that interview you aren't going to spend a lot of time focusing on writing samples. And a lot of times they won't even be read. The law firms will just request them. But when they do read them, it can really do you a lot of damage if you're making errors. And it can be, in many cases, much more important than your resume. If you're looking for a position, anything to do with any type of litigation inside of a law firm, pretty much what you're spending the majority of your time doing is going to be writing. Because you're doing so much writing, they take it very seriously. And you have to put a lot of pride into your writing, especially if you're a litigator, because that's what the job is. Being able to write directly, being able to write without mistakes and so forth is hugely important. One thing that I do, and I'm just telling you this because I believe it's extremely important, is I use systems like Grammarly, which is an online tool you can buy, Pro Writing Aid, and others like that. And the reason that I use them is because they're pretty good at catching errors, and I run everything through them. And typically, even if I'm sending a long email, I run everything through them because you don't want to make any errors if you possibly can help it. And it's very important to use those. And the idea, the way writing samples are scrutinized after interviews, anytime I've had someone that I've hired that is a litigator and I've looked at their writing sample, many times I decide that I don't want to hire them as much as I need them because of the writing sample. Writing samples make a huge difference. Any litigator that I've ever hired that's been a problem typically would have had a very bad writing sample. So writing samples are very important. And the whole idea of being an attorney, which is a very important thing to understand. One of the most important aspects of being an attorney is your ability to write very clearly, directly, and without errors. And a lot of people won't tell you that. Many times attorneys come out of backgrounds in political science and things like that, and they don't really realize that. But the better writers and the people that are more attention to detail is really a quality of the best firms. When you look at the firms that aren't as good, many times, poor writing and mistakes. It's very important. And taking the time to make sure that all of your email and other written communications are as clear as stuff as they can be is extremely important. And it makes a major difference in terms of your success. So I'm going to talk today just about some fairly simple writing sample tips. And I'm also going to make sure to give you some ideas that can help and not hurt candidacy. So the first thing, as I said earlier, is you really do need to proofread your writing sample multiple times. And when I say proofread, not only do you use online tools and so forth, but to the extent you can, you look at it from different perspectives. So you look at it in the morning, and then you look at it in the night, and then you look at it the next morning, you look at it the next night. You need to really make sure that when you turn in things, the language is very good. The difference between attorneys many times in the biggest and best firms and attorneys in the smallest firms is the amount of time and so forth that they put into the quality of their written work. And so your written work needs to be outstanding. And it really, even in your own firm, if you're writing very well all the time to partners and other people that you work with and outside counsel and outside people, it's going to make a big difference. They're going to think more highly of you. And it's almost the way you look personally, the way you look when you write is also very important. Your work needs to be completely proofed and error-free. Lots of attorneys lose jobs when they're young because they don't do the best work. They believe they're excited to write down what their ideas and then less excited to fix it up. But you have to really tighten things up and make sure that they're good and always look over them. And again, the quality of a good attorney, sorry, I'm in the middle of a rainstorm and quiet. But the quality of a good attorney is many times has a lot more to do with their ability to proof things and make sure they look very good than it does just to have good ideas. And then your writing sample should show at its best. One other thing I just wanted to bring up to you in terms of writing samples that's very important to understand is when you're writing a writing sample, when you're putting anything down on paper and you're reaching legal conclusions and making arguments, if the client sees that there's typos and other errors in it, what they're going to believe is they're often going to believe that that the quality of your logic is bad as well. So if your logic is rushed, then your writing, then that means that anything that's in your writing probably can't be trusted. And so the best attorneys typically will be very methodical in terms of what they write down and how they think through ideas and so forth. And when they do say something, it's typically right. As part of my job, because I'm a former litigator, I'm always in the middle of or have various cases and things that are, I'm working with attorneys on, and not as part of my job as CEO of this company. So right now I have someone that's infringing one of our trademarks and copying one of our businesses. And I have other things. And as part of that, I'll always there'll be attorneys working on it. And I'm thinking of two cases right now. One case that I'm working on right now is a trademark infringement case, and I have two lawyers on it, one from a very big firm with a very good experience and very well known, and the other from a smaller firm. And the attorney from the smaller firm that's not as well known, obviously, tends to reach a lot of conclusions very quickly, and many of them are, not many, but a few of them are wrong. And the attorney from the larger firm doesn't reach a lot of conclusions, doesn't write a lot, but when he does say something, he only says 2 or 3 sentences, and it typically will take weeks or hours away from it's very well thought out and very clear and direct. And so one of the signs of a good attorney is the ability to be clear and direct and to not make mistakes. And it's something that's important to learn that kind of comes through in writing samples. So when you're writing the writing sample, you always want to look for typos. You want to look for things like extra spaces between your words and sentences. One thing I'll also add is that there are in Grammarly and Pro Writing Aid and other things, there's ways to choose UK type English versus English. And some people think it's cool to choose UK English if they're in the UK, and if they're in the US, it's not. You want to write US language. If you're writing, if you're doing case citations and so forth, you want to make sure everything's blue book. You want to make sure that you have substantive citations to things. And then if you do make propositions and you're arguing case law and stuff, you always need to make sure you're citing different things. You need to have cases supporting it. And there are law firms that will have people check that stuff. I don't think most of them do, but there are ones that will. So it just has to look good. And then you should be very clear with your formatting and so forth, and all the indentations are consistent. And then your font should always be the same style. That's another big thing that people mess up, is they'll have different fonts and different font sizes. And all that stuff makes a huge difference. When I look at resumes, by the way, when people are applying to work with me personally, I'll always look, and I can usually, just because of the training that I've had, I mean, you good at it over time, I know I'll look at something and I'll see these spacing errors or a problem with a font or something. And that is always sticks out, and spelling. So you really have to review things carefully. And I don't want to beat a dead horse with this, because it's quite a lot, but you need to be very careful. You should always print things as well and review it that way, as opposed to just on a computer screen. And many times reading things sentence by sentence is important. Looking at things again and again and making your brain slow down, you'll just have a better chance to catch more errors. So I apologize for spending so much time talking about this, but nothing can help you more in your legal career than being good at this. And a lot of any job you have that has to do with writing, whether it's a corporate attorney or whatever, or a litigator, any type of writing you're doing, you have to be very careful. And the more you catch typos, the better off you'll be. And then the only other thing I would say is when you're sending emails with your writing samples, I always think it's a good idea to send it as a PDF. Sometimes their word processing programs will open in a different format and make errors. So if you send it as a PDF, it's not going to change. And so always try to save things as a PDF. And because sometimes Word documents will pick things up the wrong way. And that's, in terms of proofreading, often it's a good idea to have people proofread your things as well. And a good proofreader can make a huge difference in terms of the quality of things. I've had from BCG, for example, I write a lot of articles, and many times I've had professional editors look at things. And if they look at an article, they will typically chop it up and make it shorter and do other things. And it will actually become a much better document that people read more and does better. Many times, even a professional editor looking at your stuff can be helpful. And again, I don't know the ethics of that, though, if you're turning into a law firm as your own product, but just getting a sense of how a professional editor would edit things is often very important. They can do a very good job. And just one final thing that I'll say, when I started my career at Quinn Emanuel, and they had a certain writing style. Anytime you look at a really good firm, many times they'll do certain things that they'll have it as a matter of course for how they do their work product. And a lot of times outside people wouldn't know that. But because judges are reading things and judges are rushed, they made sure that almost you could never read a document more than a page and a half before there would be a new capitalized subject headings and so forth, whether it was 2A, B or something. I might even have been, I think it was a page and a half was the rule back then. So it's meaning that everything read very easily. There were never very long paragraphs and so forth. And that way it's off the documents a lot easier for people to read. So all this stuff, and that made the firm, I think, is one of the reasons this won a lot more than a loss, because it communicated ideas when other people couldn't. And I also noticed that when I was a clerk, that the people that wrote the best were typically the best firms and everything was the shortest and so forth. So the other question is that a lot of people have for corporate transactional, which could be corporate, real estate, all sorts of things. Do you need a writing sample? And these are unique situations, obviously. And a lot of firms will not ask for writing samples from transactional attorneys and want to see deal transaction sheets instead. But deal transaction sheets often are also very important because they can show your experience. They can show your writing style, attention to detail, organization abilities, how you're presenting information, and whether or not the reader can understand the information you're processing. A transaction sheet, an example would be if you've done corporate transactions in M&A and then securities and everything, you would break that up and you would probably want to have everything organized in a way that makes sense, whether it's by when you did it or the type of transaction, but people want to be able to understand that. And also corporate attorneys often do memos and so forth. You should, I would think, have some sort of writing samples no matter what your practice areas are. But one thing I will say, this is just very important, is if you are a transactional attorney, I think one of the most important things for any transactional attorney, especially in a market that is fairly busy, is always having, or where it's not that busy, is always having a transaction sheet. The reason it's important to have a transaction sheet is it shows that you have a lot of pride in your work, that you're building up a resume, that you're excited about what you're doing. And very few people are like that. Very few attorneys really come out of the gate and show that they're what they've done in that way. And so having a transaction sheet is very important. When I started in this business, the recruiting business, I met the person at the time was probably the most successful recruiter in history. And he had he had a list of every single placement that he'd ever made, along with a little blurb of it. And I guess it's funny, but right now anyway, I'm not going to brag, but the point is that he was very proud of the work he did. So anytime he was trying to recruit someone, he would immediately want to meet with, and then the first thing he would do in this meeting, he would break out a list of all his former placements and show them that to them. And that was his transaction sheet. And because no one else ever did that, anybody that he ever approached and met with would become his client. And so it's almost like that with your transaction sheet. If you put that together, it shows a lot more. A lot of people don't do those. And then if someone's reading that they'll recognize things they may have done. So I believe the transaction sheets are extremely important for every attorney to have. And if you're a transactional attorney, and I think it really can set you apart into something that so there's obviously questions about the length of your writing sample and how much is enough. But typically, most writing samples are 8 to 20 pages. People just want to see your ability to write enough that they can analyze things closely. Persuasive memos are also interesting, but I think that a very dense piece of writing can often be shorter. Most things need to be at least 8 pages, I think, to provide enough substance to evaluate. The law firm's going to want to get a sense of how you're able to shorten things, so the depth you're able to go into, how deeply you can understand various issues and so forth. And so sometimes a longer document is often important. And you can always ask how many pages that they want, but I do think that maybe 20 or 30 pages is probably the maximum. I also recommend sometimes going into interviews and actually bringing a copy of a writing sample. That can be very helpful in a resume. People like that. And it shows that you're prepared, just as having a transaction sheet shows you're prepared. Good attorneys, by the way, when they meet with clients or they meet with judges, will always have information that people are asking for. So this is just the way to think about it. And, so you want to anticipate in advance how much information people want. And obviously giving them a huge writing sample of 100 pages is not something anyone's ever going to. So you need to be careful about that. I did want to talk about one thing real briefly, and this is related to this, and I think it's important for you to understand, is part of the job of the best attorneys and the best people really in any profession is to make the people around you that you're trying to get work from, or you're trying to get a judgment from. If you're a, litigator going in front of a judge, or you're trying to get a client, is to make those people feel good about themselves and make their jobs easy. The example that I gave you of Quinn Emanuel, they would never write more than a page and a half before they had another subject heading. That was because they wanted to make it easy for the judges to understand what they were reading and never get lost. And so that's something that makes it easy. Whereas where someone that doesn't think that way would have text that might go on and on. So that's very important, is to always make sure that you're not making your reader work too hard. Edited things also make it so your reader doesn't have to work too hard. And that's very important. So you want to do that as well to the extent you can. Just make stuff shorter and longer. A writing sample doesn't make people have to work too hard. Having your writing sample with you when you go to interviews means someone doesn't have to follow up and get it from you. That's making your interviewer or the firm not have to work too hard. Having things that are well proofed and short sentences and so forth is making it so your reader doesn't have to work too hard or to understand the meaning. So you can take a sentence that may be 15 or 20 words, and if you can make it 7 or 8 words, that's great. That's the whole kind of idea of Hemingway. He was a journalist, and it used to be, he learned this way, I believe, is that you had to communicate a lot because they were using wires and so forth to communicate stories back then. So the shorter your sentences were and so forth, the easier and the faster things could be communicated to the paper, and you could make deadlines. So he was in Paris and writing for people in the States and so forth. But that sort of very clear, direct language also makes it easier for the reader. So if you can write short, direct sentences, that makes it much easier for your readers too, and then they can understand it. So that's something to think about. But just making things easier for everyone you deal with. And that's really a sign of people that are very good in all professions, is they just make people feel good, and they make things easier for them, and they don't create issues where there might not otherwise be them. So the other thing is you want to use an introduction overview to provide your reader with context of what you're writing. So what that means is just a short introduction to tell people what it is. So an example of a question would be, should I include an introduction to my legal writing? How the reader know if I'm writing about what I'm writing about if I take an excerpt from a longer brief. So everything should just have a short written introduction to what you're doing. And this will ensure that the reader's not missing any context. And often you can just put it on the cover page and with a short little overview of what you're writing and what you've redacted and so forth. And just make sure that you tell people if the writing is all your own work, or whether it's a collaborative effort. Like, for example, if you had an editor, you could say it was edited. I don't know, that would impress them though. And or if it was written with another partner and so forth, whether it was a collaborative effort. Typically, you're going to be much better off if you show things that you only did, because if it's a brief and some partner's names on it and yours, they're going to assume that someone else proofread it. But a short introduction is good. One of the things about introductions, by the way, providing your reader with context, is law firms, just as you would if you were hiring, love people that can be enthusiastic about what they're doing. So anything that shows a lot of pride and enthusiasm, a transaction sheet, by the way, shows enthusiasm, writing a good introduction and overview that shows enthusiasm. So anything that shows enthusiasm for what you're doing is really important. There's so many people out there that are enthusiastic, and the people that go the farthest in any profession are the ones that are enthusiastic. Obviously, I'm enthusiastic about what I do. And when I'm looking to hire attorneys, I hire the ones that I know are the most enthusiastic about what they do. When I've hired so many attorneys. I've spent a lot of money over the years hiring attorneys, and the ones that I've hired are mostly the ones that I worked with in the past that I knew were really enthusiastic about what they did. And the ones that weren't enthusiastic were the ones that I did. So anytime you imbue a little enthusiasm, it is important. And then make sure if you're providing a sample, that you make sure that people know what you're doing is just a sample. Many times on each page, people will write sample. If they do a redacted sample, they'll write that. One of the things is I prefer to have samples that aren't redacted. It's just when you have a sample that's redacted, it detracts from the main message, because the person has to read all these, where it says redacted and stuff, and it just looks self-important. It's stupid. I don't know. I don't like it. So if you can, it's always better to provide something that hasn't been redacted. And then this question about what's confidential or privileged that you can't write. First of all, typically a memo that's to a client about one of the client's legal issues is typically going to be a privileged type of thing, because it may be done in terms of anticipation of litigation or during litigation. Something about a law, just a quick memo about that, which people do all the time. is probably not going to be confidential or privileged. If you're asked to write a memo about if the federal rules of civil procedure apply to a client or something, or what rule applies, you would just maybe take the client's name out of the memo and turn in the memo as a writing sample. You need to be somewhat careful, and as a general rule, anything that's filed with a court that's not under seal is not confidential or privileged. And most of the time, when they ask for writing samples of younger attorneys and law students and so forth, all the stuff that you're writing is just you're asking if certain things apply and so forth. And so it's not, or certain laws. So you can certainly check with your local rules and bar association if you like, but for the most part, that's pretty much how it goes. And people aren't really looking to get you in trouble when you turn in a writing sample. They're just looking to get a sense of your writing ability. And again, this is just a little bit of notice about what is confidential versus regular information and things that can be used as a writing sample. And then this is another question about redactions, what to do if your writing sample is confidential and privileged information. So some people will change the names of companies, but most of the time, again, as I said, I don't like to really use redacted samples, but you can certainly redact things. And if you put it in a Word document, again, if you put it as a PDF and you redact it, it's much harder to reverse engineer. And just be careful with that. So again, just be careful with any type of confidential information. And I've had times where I've interviewed people before and they've talked about confidential things with former clients or current clients. And because of that, I didn't hire them. I've had people turn in documents that I knew would have been confidential when they're trying out for jobs and so forth. And you just need to be careful with all that. And these are just a bunch of questions about redacting things. Again, I don't like the whole idea of redaction because it's just, if you have to redact the name of a client 100 times in a document, the document's just going to look like it's some sort of UFO document about the federal records or something. And it's stupid. I just would be careful. When you're turning in documents that you may not have written yourself, again, when you write it with a partner that may have made some changes, you have to be careful. Most people are going to realize that someone else has probably edited it very closely. And if you did write a section all on your own and no one else looked it over, then you can certainly do it that way and then say the sections you wrote. But if two people's names are on it, someone's going to assume that someone else wrote it. One of the things that I think is just very important to realize is that when they're looking at your writing sample, they're really looking to see your ability to proof things carefully, your ability to do that. So if the second someone's name's on it, they're going to really assume that you may not have been, they're not going to have a good sense of your attention to detail. And they're not going to like that. Same thing with published articles. I don't know if you've ever turned your things into a law review or had things published, but most publishers have teams of editors and things. And so that's the same thing with the published article. The people will assume that other people have heavily edited. People want to see the document. When you write a document, people want to see what your writing style is like. And I know in the patent field, and actually in some law firms, they will actually call you in and have you take a test where they'll make you write something and give you a certain amount of time to see your skill at editing and so forth. And so, that's something I would recommend. And a lot of times people are very proud of publishing articles, but the fact that you publish articles in many cases is not the best thing in the world. For example, some firms you would be considered that are so busy, they'd be like, why wasn't this person billing hours and so forth? I remember when I was working, this is a funny story, but I was working and this is probably a little upsetting to some people to hear, but I'm going to tell it anyway. I was my second summer of law school. I was working in a big New York law firm, and I was talking to a partner, and I was saying I was thinking about doing this clerkship, and the partner said, "It's one thing I regret about being at this firm is that if I was at Cravath, people would never think about clerking." So the idea is that Cravath is considered one of the top firms in New York, one of the top 3 or 4 maybe, and so the idea would be that people from Cravath typically don't clerk because they get such good experience working in Cravath that they would never in a million years want to clerk. And so it's very presumptuous. And obviously there's people that clerk and go to great firms and so forth. So I don't think and I clerk. I'm not, again, at levels. So if you're a first year associate and publishing all these articles, people are going to wonder many times, or even a second year, how you have the time to do that and bill hours. It's just something to be a little bit careful of to some extent. But I think it's good to write articles if it can help you get clients and build a name for yourself, but it doesn't always help you. I was talking to a partner at a big firm, Kirkland, actually, not too long ago, and he'd published all these articles, and I was very impressed. And he said, "Well, you shouldn't be that impressed because I wouldn't be doing all this if I had enough billable hours." And then he wasn't that impressed with himself. The point is, it's good to write articles, but if you are writing articles, you have to be many times very careful about drawing too much attention to it because other people are going to assume that it's edited if you try to. And then sometimes people ask if the writing sample should contain, let's see this question here, the facts section of a brief. The ideal writing sample should your analytical and persuasive abilities. I think facts are not the worst thing in the world because it can show your ability to tell a story quickly, but they're not very good for showing your argumentative skills. And many times people want to see your research skills and your ability to apply the law to issues. So that's important. But you can certainly turn in the facts section if you want. I think the ability to tell a story is a very important thing for attorneys to be able to do. So I'm not necessarily against it, but most law firms and stuff want to see your analysis. And then there's different alternatives. There could be persuasive letters for legal writing samples, and those can be okay. I've seen people like real world writing samples. I've certainly accomplished with the letters in my career, both for getting people jobs and so forth, because you can be very persuasive in a letter, many times in a way that you wouldn't be in other alternatives. And many attorneys, by the way, especially in different practice areas, really do have a lot of experience writing good letters and have a good reputation for being good. Another thing is in terms of the recency of a writing sample. If you're a practicing attorney, you probably shouldn't be using something that you wrote in law school. Your writing skills should continually be improving, and it's important. It looks ridiculous if you turn something in you wrote in law school when you're asked for it when you're practicing. Doing something more contemporary is very important, whatever you have. And again, I keep coming back to this, but proofing things is important. Again, this webinar, I guess someone sent this to, it wasn't me that sent it, but when it was sent to all the BCG recruiters asking if they had any advice on the subject, and everyone said proofread it. Preparing writing samples can be very hard work, and reading stuff can be difficult. A writing sample is really an opportunity to not get a job. So if you make a lot of errors in a writing sample, it can hurt you. And again, in most job things, you'll be up against multiple candidates. There's always, one of the things is in interaction you have with people, there's the rule of threes. And I was talking to someone about this yesterday. 1/3 of the people that you meet will like you. 1/3 of the people won't care. They won't like you or dislike you. You just won't make any impression. And then another third of the people, for whatever reason, will be more negative towards you than positive, meaning maybe they think they don't like athletes, or maybe they don't like nerds. Who knows? They just don't, or they don't like you. You just remind them of someone. And it's like that with most people when they interview. There's always going to be a percentage of the people you interview with that probably aren't going to be particularly enthusiastic about you. And there's going to be people that are on the fence. So if you do a bad job with your writing sample, you'll give those 2/3 of the people that don't care and the people that don't like you more room to dislike you. And so you need to be very careful with that. So I'm going to take a quick break just for probably, let's see what time is it? Just for 1 to 2 minutes. And while I'm doing that, if anybody has any questions about this webinar or anything you'd like to ask about just put them in the chat, and I will go through as many questions as you have. This is actually my favorite time of the week, is answering these questions. And there's always great questions, and you can ask anything you want. It doesn't have to be about writing samples. It can be about your job search or any questions you have. And I will stay here as long as people have questions. I do it every week. If you have 100 questions, I'll try to answer them all. Hopefully you won't, but however many questions anybody has, I'll do my best to answer all of them. And I will be back. It looks like it's 10:44, so I'll be back probably by 10:47 or so. Nice. All right, let's get the questions. Just give me 1 second. I'm going to open a Word document here so I can put the questions in there. Give me 1 second. Sorry. Got a whiteboard here. Okay, so let's get to the questions. Give me 1 second here. All right, give me 1 second. For some reason, I can't see the chat. So give me 1 second. Oh, here we go. Okay, Q&A. Perfect. Okay, so the first one is, I'm actually starting at the bottom here, is what are the most common writing samples? So people typically, what'll happen is junior attorneys will typically don't have experience writing briefs and so forth for the court. So they will turn in memos and things that they've done about different issues. And that's actually okay. That's what's expected. If you're a law student, people will often turn in, new court documents, that sort of thing, briefs and so forth. And then young attorneys newer attorneys will get memos. Typically, that's what happens when you're a new attorney. And then after 1 to 2 years, maybe 2 years. Typically, people will turn in motion briefs, things along those lines, that they sign. So you're saying, so those are the most common ones that people use. And yeah, let's see here. So the next question, it's actually the first question asked. I was a summer associate at a smaller firm and accepted an offer to return, but it's a little bit bigger for you guys after law school. Let's see. Return at the top 6 law school. I accepted the summer associate and post-graduation hours from this firm because I didn't get a job at a bigger firm. And now when applying to larger firms and getting them offered to smaller. Would this be unethical? Is it too late to begin looking? If I wanted to do a 3L job search, where would I start? It is very difficult to find open positions in litigation for my class year entry level. Any advice would be greatly appreciated. Okay, so I'm going to answer this question in what I consider the right way, but not necessarily the wrong way. So that may be the wrong. One of the things that you have to understand about being an attorney, and regardless of the practice area that you're in, is you do need to look out for yourself. And what that means is you need to put, your interests, long and short term, first when you make important decisions. And this is, again, a very important thing. So if you go talk to your school about what you're considering doing, you talk to your school, the school will say that you should go to work, regardless of the school. You should work where you accept an offer. They're doing that because the school is putting their interests first, which means they want to make sure that future people make sure the employer is not upset with them. And so that's what they're going to do. Now, in your position, you need to decide what is best for you in the long run. And in the firm's position, if the firm doesn't have enough work, firms lay people off and do not let them start. Do not let people start all the time, even with lawsuits. Basically, the law firm has the right in May decide not to even bring you on, even after making you an offer. And they won't do it probably this year because it's a good economy. Most of the time, they have that offer. Your position is, I'm assuming, is you want to get the best job possible. And you have 2 people standing in your way, your school, or in your conscience, or your conscience. So my opinion is that what is going to be best for you in the long run. And just going to a bigger firm isn't what's best necessarily. A big firm, and there's a presentation that I did a couple of weeks ago about the benefits of working in the largest firm possible. The bigger the firm, the more options you're probably going to have in the future, whether you want to go in-house or regardless of what you want to do. A larger firm will give you a lot more options. So there are obviously benefits to going to work in a larger firm. But the other thing is, if you go to a larger firm, even though you may make more money and so forth, it may actually be harder for you to become a partner. You may have less employment security because people, especially litigators, typically will lose their jobs in larger law firms after a few years. So there's all sorts of, after they get more senior, there's also, you may have worse hours. There's all sorts of reasons that you may not want to where you're at. But what I would say is if you accepted an offer and you feel like that's what you want to do is best, to go there. If you feel like the cost benefit analysis is in your favor, but if you feel like you really need to work in a larger firm because of whatever reason, then I would do a couple things. The first thing I would do would be, I don't know if there's any NALP regulations about if you accept an offer, you can't do things, or in terms of recruiting, I'm not aware of any, but maybe there are. I certainly see nothing wrong with talking to people if it doesn't in other firms to see if it may be something you want to do. Even though you weren't a summer associate in different firms, you do have the option of applying to larger firms. And even though the market may be slow where you're looking, the market is not slow nationally. If you're a top 6 law school, you can probably go to work in almost any market in the United States. If you're in Chicago, for example, then you may find that California, Los Angeles is very busy, or New York City is or DC is probably not that busy enough for litigation, maybe busy, I don't know. So you have to be careful. But what you do need to understand, though, is at some point, the law firm may check your references at your firm that you were at over the summer. The odds are pretty rare that they would, unless they were almost positive going to give you an offer. But yeah, that's kind of how I would think about it. The only other thing I would recommend doing that's very common is if you want to go to a larger firm, you should try to clerk. So clerkship with a federal district judge repellent, will make you much more marketable. And then you can probably go to work at a larger firm. And plus you'll get very good experience and have someone critiquing your writing and so forth for a year would be awesome. So that would be what I would do if I was in your situation. I would probably take a clerkship, and the smaller firm's not going to care and we'll assume you'll come back. If you don't come back, you can go to work at a larger firm and get a clerkship bonus and all sorts of stuff. And then get very good training right out. One other thing I wanted to say to all young attorneys and law students on this call is really your first job, your first 1 to 5 years of practice are really about getting. So that's the most important thing to really realize. So the better training you get, the better off you're going to be in the long run, because you're going to learn like all these skills that I was talking about today with writing and things. Like most people never get exposed to that. Most attorneys do not come out after their first 3 or 4 years of practice as very good writers. They don't come out with the best logic. They don't know how to make decisions in the correct way and analyze information. And you learn a lot of that stuff early on. You can learn that by working with a very good judge. You can learn that by working with the best people and the best firms. And you can learn that if you work in a very good boutique where you're working with very good people. But the first 1 to 5 years are about training. You should never worry so much about prestige and money and getting an incredible experience, incredible training, because that training is going to go a long way in your career. If you're 26 years old right now, let's say you're 25 when you come out of law school, you can practice. People now practice into their 80s. You'll probably be practicing into your 90s. You'll probably be working into your 90s, maybe longer, because people live a lot longer. The groundwork you lay early on in terms of the habits you learn are going to be extremely important. All this stuff about learning to think through issues, learning to write properly, spending your time around the best people you can is all very important. I told the story a couple of weeks ago, but I just want to bring it up again very quickly. I used to be involved in the self-improvement industry, and there was this guy that I met, and he'd made probably hundreds of millions of dollars putting on real estate seminars, and then he'd gone and something had happened. I don't know, he'd exhausted himself or gotten in trouble or something. Not in trouble, but just his life fell apart. And so he spent like 1 or 2 years going around and meeting the Dalai Lama and all these people, anybody that he could spend money to get education from about the meaning of the world and life and everything, and spent a couple of years just traveling. And then he wrote everything down, but of course, because he wasn't very educated and so forth, and I'm not saying didn't know how to write clearly, I read all this stuff and couldn't understand it. And so I met with someone that worked with him very closely, and I was like, what is it that this guy understood? And basically, what he understood is that, and this is a very simple model to put together for you, but the people you spend your time with determine the type of person you are. And that was really it took me a long time to figure out. If you spend time with the best attorneys when you're young, you will become like them and learn their skills and have a much better career. So if you can spend 5 years getting really good training, those 5 years are going to make you a very good attorney. And then for the next 60 years of your life, which is 2 times as long as you've lived at that point, you can be a very good attorney. Whereas if you don't spend time with those attorneys, with those sorts of people when you're young, you won't do as well. And that also goes into, I was reading a book about early development, and most of our right and left brains our left brain, which I guess is your logic and reasoning and center, doesn't really start developing until you're a couple of years old, but your right brain, which is emotions and stuff, really develops pretty much your first 2 years based on how your parents interact with you. So if they give you a lot of attention when you smile and stuff, that actually has a long-term impact on the type of person you become. And it's the same thing with, why do people try so hard to go to good colleges? Why do people try so hard to go to good prep schools? Why do they try so hard to get on certain teams and so forth? And it's really because of the people you're around determine the type of person you become. So as a young attorney, because you go to a top 6 law school, the pressure there, which makes sense, is work in a big firm, work in a big firm, work in a big firm. And the idea is that that's because those groups push that. And if you're going to a small local law school and outside of Detroit, your pressure would be try to work in this big Detroit firm. If you can't work there, a couple of big Detroit firms, maybe you could do this other thing. So the groups of people you're with determine the pressures and stuff and your aspirations, but also your training. So I would recommend anything you can do if you're a young attorney to work with the best people you can, that are going to give you the best results in the long run, and spend your time around the best possible people. I had one other experience, and then I'll shut up and move on to the next question. But I think it's a very important question, what you're asking, because it ties into so many things. There was this, when I was practicing law at my last law firm, there was this woman there that was a partner at the firm, and she wasn't doing well, and she'd been ties and was very angry. But anytime someone worked with her, like, they would quit, like right after working with her, and then they would not practice law again. Like, one woman had gone to Columbia Law School and worked with her, and she'd become a waitress. Another guy had gone off the deep end and was traveling, and it was just all these stories. This woman would call you to do work for her, and then within a couple of months, the person's not practicing law anymore, and it was literally that upsetting. And of course, the story goes that I worked for her, and reached a conclusion that I didn't want to practice law anymore within months of working with her as well. And she was just very unpleasant, couldn't understand anything, was mean, was very political because she got in ahead. So if she didn't like you, which she didn't like anyone that did work for her, she would be mean. She would play games. And so it was just, so that's and that was how she was able to get ahead. She didn't have the same education and so forth as everyone at the firm and so forth. So the people you're around often determine the kind of person you become. And that's one of the reasons why you look for positions and you try to work with the best people you can and go to the best schools. It's all because of that. And it's something to remember in your career, because the people that you're around and you spend your time with will determine the type of person that you become in your career. And then that's going to have a lot of long-term impact. And your first job can determine that. Working with a judge that you like can determine that. All these things can determine that. And someone once said to me also, which is an interesting thing, I was talking to my dad, and someone hadn't worked out at the company, and I was saying, oh, yeah, but nothing good's happened with them. And he said, well, you should be proud of, you should want good things to happen to the people that leave. That should be what you're thinking about. And so, he's right. Or he was right. This was 20 years ago. And since that time, there's all sorts of people in this profession that are doing very well and well regarded. And they certainly didn't have exposure to that when they started, and they become very successful. You want people that associate with you to become successful. And so you want to be part of organizations where there's good stories about people that leave or people that have been there in the past, and not bad stories. And that's very important. So I hope that helps me answer your question. If you have a follow-up question, I'm happy to answer it. And then the next question is, what is good legal writing? What separates it from bad legal writing? Good legal writing, good legal writing typically is understandable. It's short. I'm not short, but it's understandable by all audiences. So it's almost many times, fifth grade level. The worst attorneys will typically use the biggest words and the longest sentences, and things will be the least understandable. And the best attorneys would be the most direct. So good legal writing does that. It also captures and doesn't miss issues. You have to understand all the issues. And so one of the fun things, a very good legal writer who's a little bit long-winded, but is like Posner, for example, in his Ninth Circuit, or used to be, I don't know if he still is, but his writing was always very fun to read, because he would write these, long opinions, and the opinions would go on for pages and pages, and they were very understandable and entertaining. And then he would conclude, you would get like one or two like short paragraphs away from conclusion. And all of a sudden you would think it was going to go one way, and it would turn everything on his head by the last moment introducing a piece of information that was part of the conclusion, but no one had thought of, or didn't look like it was going to go one way. And the opinion would go the exact opposite. He does that a lot with a lot of opinions, and it's fun. And so it's that too. Good legal writing doesn't miss issues. And so I would just make sure, if you're writing something that, that people understand what you're talking about, then you're not missing things. Okay, let me get this one. Next question. And so good legal writing, bad legal writing, I would say, just is a matter of course, it uses big words when it doesn't need to, is longer than it needs to, it misses issues, there's so many rules to legal writing. One of the things is, if you're going to have, I could go into a lot of detail, but a lot of times people will have subject headings, and the subject headings you might have argument, or you can say argument. Instead of argument, you're better off actually writing what the argument is. There's not blah, blah, blah because of such and such. So a lot of times people will use arguments. All these different subject headings basically describe what's there. Your subject heading should be descriptive. There's so much things about good legal writing compared to average legal writing. But one of the things I would say is, if you're doing this for a living, and if you're in the legal profession, you should always be doing whatever you can to learn and to read books about things, and to be very careful about to constantly be improving your writing. It's important, and especially if you do it for a living. A lot of times you can learn things very quickly without having to stop making mistakes over and over. And the next question is, when should I submit my writing sample? And one of the things I just wanted to say about writing samples is I had an attorney working for me not too long ago, and she was very arrogant and thought she knew everything, and her writing was horrible. She was actually from a foreign country. And I told her at one point, she was, she would make a lot of bad mistakes and wouldn't communicate the right ideas and wasn't thinking through things. And I told her at one point, you're never going to get ahead in this profession. And she was just working as in a kind of a contract role, doing some stuff, if you continue with this. And she didn't like hearing that. And she was very upset about it and ended up actually, I think, returning to her country. She was so upset to hear that from me. But I was being honest with her because I'd given her several warnings and told her that I'd bought her a lifetime subscription to Grammarly or whatever it was, or ProWriting, I think, and all these other things. But the errors just kept happening. And the other thing was the writing errors happened, but also the logic errors. Learning all this is very important. It's part of the job. Again, if a client sees a writing sample with errors in it, they're going to assume that your thinking process also has writing errors in it, and that's going to hurt you. And people don't want to be represented by clients like that. They absolutely don't. I had an instance once where it was actually embarrassing, but I'll tell it. I was living on a farm when I was in law school in Charlottesville, Virginia, and these neighbors of mine, they had taken their dog to a kennel, and the kennel had lost it and lost the dog, and he'd gotten out or something, and so they were upset and they wanted to sue the kennel. And so they had me draft a little complaint for them to file in the small claims court. And I did, and there were errors in it, and they took it, and then they came back and said, correct these, and then they took it, and there were more errors, and they came back, and they took it, and they came back again on their errors. And I realized that, and these were people that were farmers, essentially. They were not sophisticated people, but this is someone that at that point I was a law review and getting ready to do a federal clerkship and all this stuff. And I was still making errors like that and not taking it seriously. The point is that people take this stuff, even the clients, very seriously. And if those people were to probably never would have used me, even though thought I was such a big deal. And I wasn't a big deal. I was a hack at that point because I didn't know what I was doing. You need to do the best quality writing you can, and you need to learn it. And even people that aren't educated are very insulted and hurt by those errors and lack of attention and so forth. The question about when you should submit your writing sample is don't, unless they ask. Writing sample, anything that many times, unless you are so confident that your writing sample is awesome and it's not going to hurt you, I typically would not submit a writing sample unless someone asks. Don't put writing samples available or references available on requests and so forth on your resume. If they want it, they'll ask for it from you, so don't worry about that. But in terms of your writing sample, the reason you don't want to submit a writing sample unless they ask is because it's just an opportunity for them to find things wrong and find mistakes. And someone may decide that they don't like it. And again, every law firm, not all of them, but a lot of them always have their writing gurus that are in the firms. And those writing gurus, most of the time, and I'm not, again, trying to be rude here, but a lot of them do not. And their sense of importance and value to the firm comes in shooting down not only the people that work there as writing samples, but law students and other applicants writing samples. You need to be very good about making sure that you avoid those people if at all possible, because they will always put in a bad word for you. There's very few writing samples that those kind of people ever receive that are going to get a lot of praise. They'll typically all be marked up, and any writing sample can be torn apart. I've had experiences. I had one funny experience actually where I thought that I learned all this stuff about writing samples, by the way, from clerking and from working with someone that took them very seriously in clean writing, which I'm grateful to this day. But one of the things is that one time, I've had instances before where people have given me writing samples and I've marked them up with 5 different colors of ink and everything and done a really good, spend a lot of time on them. And then they've brought them back corrected, and I've done the same thing with them again. And people are like, that's just crazy. But so many times there's people you just can't please. And so you have to be very careful. Is it possible that a writing sample will be used against me? For the next question. And yes, it is. If you don't turn in a good writing sample, that will be. It's not going to be used against you if you send someone, there's client confidences and stuff in there. That's not going to be. But if your writing sample is not good, it's going to hurt you. So you need to be very careful with that. Okay. I did an interview with a large law firm, called back with a big law firm on Friday. They emailed me asking for a writing sample. What does this mean? The callback has already happened. Well, you need to get them a writing sample immediately, so do not delay. And it's actually good if they ask you for a writing sample. Sometimes law firms, there's two types of law firms. Some require it from everyone. Some require writing samples from everyone, and others don't. And most of them, if they've asked you for it after the interview, that probably means that they either need to get your file ready for review or you're in the running. And in most likely, what that means is you're in the running for the job, and they may just want to have that as part of your file before they make an offer. So I think that's great. But I would try to give them the writing sample today if they asked you on Friday, because the more time you delay, they're not going to like that. And many times law firms are ready to make offers fairly soon after interviewing you. So I would work. Okay, the next question is, I can understand that asking for a writing sample that is already public, such as the court filing. I've been asked to provide a writing sample from a meet and confer email. My concern that this is rather confidential, even if it were to wrap up sensitive info. Technically, my law firm still owns all my emails. If they've asked you for a meet and confer email, I wouldn't worry about it. I don't think the way that you approach that is really what they're concerned about. Just redact the client information. They may actually be curious to see how you go about doing that. So I would just make sure you redact all sensitive information, or you can just change some information in there and client names and so forth to make things up. I wouldn't say ABC. I would say Big Co or something like that, whatever you want. I don't think it's that confidential. Technically they own the briefs and stuff that you write for them too. I don't think I would worry too much about that. And so I would definitely do whatever they ask. Many times when they ask you for something like that, they're looking to see how you approach things and if you can get things done. So I would do that. And maybe they want to see that because someone just did a bad meet and confer email for them that they want to fire. Who knows? But I would look very closely. Okay, I was planning on using a memo I wrote to one of the judge's clerks. I internship last summer as my writing sample. My school clerkship office suggested would be frowned upon by judges. Is that true? Maybe, but at the same time, if I don't know if you're writing for a judge, if it's just about some sort of legal issue and so forth, it's not going to be frowned upon. You can just put, here's the contents of a memo I did last summer. It doesn't have to be to the judge or whoever. I don't think that's going to be frowned upon by judges. But again, only use this memo. You can see all these kind of problems here. There's problems with not providing the writing sample. There's problems with providing the writing sample. So if you provide one you wrote to the judge's clerks, I don't see any reason why that wouldn't be permissible. You're just analyzing the law, and I don't see anything wrong with that. And you're probably not divulging any confidential information because the information is already in front of the court in terms of memos and briefs and stuff. I wouldn't really worry too much about that at all either. I am applying to regional firms after 2 years in big law. Good. When you're a clerk, I had a few writing opportunities, junior associate in big law, and came out of it without a writing sample. My current writing sample options are from an internship I wrote 3 years or excerpt from a law review article I published during my first year in my law firm. Where any of this ideal advice? If it was me, I would probably and again, this is not necessarily the coolest thing, but if you did publish a law review article during your first year, I think that's great. I would just turn that in. And then if they say, oh no, we want this, I would turn in, you've got to have a memo or something to do or something clerkship. You may have written, I'm sure you wrote opinions when you clerked that probably didn't get marked up very much by the judge or anything that you can turn in. But I think you'll be okay. Especially if you're applying to regional firms, I think that most of them aren't going to be that interesting. And then one of the things I would also tell them is if the law firm, I like your honesty here. So many times if you tell this to the law firm, just ask them what I should do and tell them what you have. Don't be a pain in the ass about it, but just be nice about it. They're going to respect you for being honest and forthright and so forth with them. But I would turn in the law review article you published your first year was what I would probably do. I think that's very impressive. It's not ideal. I probably wouldn't do a memo from your third year internship because you have so much more experience and you probably wouldn't want to anyway because you're like a 10 times better writer now after all this experience. That's what I would do. And if you have, I'm sure you must have written some memos or something in 2 years of big law. I would see if you had something along those lines that you could do is how I would approach that. Okay, the next question. Is it okay for foreign trained attorneys? But yeah, just this last question is a great question. I like it, but I would, if it was me, I would I would look for to make sure you have something, and you have to have something, or you can be honest with them. But I would look for you because you had to have done some writing in 3 years, including a clerkship. And I'm sure you've got opinions and all sorts of things that you may still have, including maybe published opinions. So you may publish opinions or law review articles. I would look into that. It's okay for foreign trade attorneys to provide the writing sample from a draft they did for their work in a foreign country. I wouldn't recommend that because it draws attention to the fact that your experience is foreign, and anything that makes you look like you're not playing the game in the U.S. is going to hurt you generally. I would try to do something that's local. Now, if you're applying to be an expert for foreign legal issues in a U.S. law firm, then that's probably okay. But for the most part, that's what I would do. Okay, the next question goes to where can I go to get questions or typos to create a new writing sample? I don't know that you probably don't want to create a new writing sample. They're asking you this information because if they're asking you for a writing sample, people are typically assuming that as part of your position, you do writing. So if you don't have a writing sample, that's going to be a problem. You've seen some examples here, like people talking about me confer emails and other types of things. If it was me, I really would try to see if you have something that you can do. If you don't, if there are questions or hypos to create a new writing sample, many times you can write about the area of law that you're in and just write a short article or something. But I would think that whatever your practice area is, there's going to be all sorts of things that you can write about. Okay, so next question is, I am looking for a job in international tax. Do you know if there are opportunities out there? And the answer to that is yes. One thing I would say, again, I don't try not to promote services on this call, but you can what I would do is I would go anytime if you have a job, to look for these type of jobs. Law Crossing researches jobs, so it's like a research company. It's not like Indeed is a job advertisement search company. Indeed is Law Crossing is a job search company. So not only can you see international tax jobs that are current, but you can see international tax jobs that have been had in the past, the firms have had in the past. So that would be Law Crossing archives. So the company's been around for 20 years, so 20 plus years of expired jobs. And that'll just show you the people that hire those sorts of people. For international taxes are just a weird practice area in the sense that many times it's a support role to corporate law firms. And law firms, when they hire tax people, they like them to be from other law firms, but there's not a lot of tax jobs in law firms. So it's just a very difficult practice area for many people to get jobs in. What I would recommend if you're a tax attorney would be to look at accounting firms as well as law firms that have had openings before. And that's how I would use it's called Law Crossing Archives. Just 1 second, I'll back. I apologize for that short break. But what Law Crossing Archives is just expired jobs. So if you're like a niche practice area, and that would be tax, other types of practice areas, a lot of times if a firm has had an opening in something like international tax in the past, it's likely to have one in the future. So it makes sense to look there. And then the only other thing I would do would be looking at old in-house openings as well. So you look at, current and expired in-house openings. And it's the same logic that applies. So just work on, look at that. And then that should show you people that have had openings potentially in the past. Okay, can you explain? So always, and by the way, this kind of goes, I just want to make sure that everyone understands this for every practice area. It's very important to try to look at expired jobs because one of the ways, like at BCG, for example, most of the placements we make, I would say 85 to 90% of them are at firms that do not have current openings. And so what that means is you can use the idea that firms had openings in the past as a guide. Certain firms may have an M&A opening every 6 months. So even if they don't have one right now, if they had an M&A opening 6 months ago, the odds are that if you send them an M&A attorney, they're going to interview them. Same thing goes with litigation. There's certain firms that are always seeking litigators at different levels, and same thing with patent and so forth. So many times it's like that with tax too. So looking at openings that are expired is often very important. The reason, by the way, that I get more people jobs at firms that don't have openings than openings is openings means the jobs are advertised and people are getting a lot of applicants. And firms getting a lot of applicants. And not always, but many times. And non-openings means not advertised, market apply. Those are just things that I recommend. Your chances of getting a job are probably 5 times greater if you apply to some place that doesn't have an opening because there's no competition. And a lot of times when you apply, like Law Crossing, for example, and this is again not a promotion for Law Crossing, but Block processing finds jobs from small websites and employer websites, and most of the time employers are not paying to advertise. So that means that you're getting a lot of places where you're not seeing advertised jobs, which is just helpful. It's just a search secret that I use in my job that is very helpful for people. Okay, can you explain the strict lockstep compensation that law firms are getting rid of? And why are they getting rid of it? And what are the major compensation models? Okay, so lockstep traditionally was used by a lot of big older firms and older law firms in the United States, and it's almost from a different time. It's also used by a lot of the big English firms and so forth. So lockstep basically means that partner first year makes this much, makes maybe 0.05% of the profit, or let's just say 1% first year, 0.025%. Let's just make it easy, 1% of the profit. And then second year, partner fifth year, 1.5, 1.25, partner third partner, and then all the way up until 30-year partner. And I'm just using this type of numbers. So the idea is as you get more senior, your compensation to the firm, your compensation increases. And typically in the oldest firms, it did not matter how much business you have. It's just you're compensated as you get older based on a lockstep, meaning everything just increases, as you get more senior. A 10th year partner is going to make a lot more than a first year, even if a first year partner with $20 million in business and a 30-year partner with zero business. 30-year partner is still going to make 3 times more than the first-year partner, regardless of the business. That's lockstep. This was when, law firms were more congenial. People stayed with them in their whole careers, more loyalty and all that sort of stuff. And that was just how it worked. The longer you practice, the more money you plan on making. And in your compensation, typically you made a lot more later in your career. Now, as I'm sure you're aware, and people like that. Certainly people could do very well under that. If they didn't have business was shared with everyone. That was supposedly a good model. Now, the non-lockstep, which is pretty much what everyone does, what happened is in the 1980s, starting in the early to mid 1980s, compensation experts, consultants, and so forth from Anderson, whoever, consulting companies, came in to law firms. And they said, this is crazy. You can't do this anymore. And there started a lot of lateral movement, partners to new firms. What had happened at that time is you started getting firms in New York, opening branches all around the country. Oh, hold on 1 second. Sorry about that. So in the 1980s, you started getting consultants. And so there started to be a lot of lateral movement. So firms are opening branch offices in New York and LA. Everyone thought, Japan was going to take over the world and it needed to be close on the West Coast. And so all this stuff started happening in the early mid 1980s, and loyalty to firms began decreasing. And then the portable business became the main compensation mechanism. And the more clients you had, the more you were business, the more you were compensated. And then that sort of became everyone out for themselves. That's what lockstep is. And so the problem that's been happening is at firms like Cravath and Davis Polk and all these other firms, it used to be unthinkable that one of those partners would leave because they were lockstep, and they would, as they got more senior, they would get more money. And so even if they were to take clients, if they didn't have clients, there's no way they would make more money in a new firm. And so this is how things worked for a long time. And that's kind of what lockstep compensation was all about. But then what's happened recently is all those firms where you never think of them leaving, now they are leaving if they have business, because they can accelerate their careers and make a lot more money working in non-lockstep firms right now. And so that's what's happening. And so a lot of these big New York firms and English firms that are trying to expand realize that they can't grow with non-lockstep compensation. And so they are moving into what's commonly called eat what you kill model. And so that's how things are working now. Now there's different types of eat what you kill models. Under a lot of firms they'll have what are called capital or, shareholder partners, and then they'll have income partners. Income partners are basically on a salary, and then shareholder partners get a percentage of the business that they bring in, or profit of those countries. And so that's how it works now. It's just something to think about in terms of how things work. And this is the way things work. So the larger firms under the lockstep are moving away from it. And the main compensation now is non-lockstep, which is eat what you kill. Firms will have different ways of distribute profits to people based on that. Some will give them only a percentage of their business. Some will give them a percentage of the whole firm. Different firms have different models. And really, it's how this model works that makes people either stay or leave. Typically, what will happen is someone who's a capital or shareholder partner will feel like they're not getting enough profits or enough money, and someone will be able to lure them to another firm to leave. And that's mainly why people will do that. And one of the things that's nice about this non-lockstep model now is it does make it, because it's all about business, it really makes everything wide open. You can literally suddenly get major clients and so forth and move from a very small firm to a huge firm. I've seen it happen lots of times once you get business. Okay, what if you only have in-house experience in your NDA prevention writing docs? Yeah, then you just can't do it. You have to give them what you have, and you can't do it. And you just have to tell people that. If you're very clear about this sort of thing, then I think you're going to be just fine. It's okay to be honest. You want to be honest with people. And so if you can't do it, you can't do it. So you don't want to do something you can't do. And I would just basically say, all I have is from law school and so forth, or tell them whatever the answer is. Or write something. Spend a weekend writing something if you need to. To apply to larger firms, what is the best way to go about it? Should I look at their website and apply for open positions, cold email partners, or what? It feels so difficult to find open positions with 3 L's and 2 late in the game. Yeah, so people talk about emailing all the time. You can do it in a couple different ways. You can contact. The partners are okay, but partners many times, so law firm partners, by the way, it's important in whatever you do to put self in other people's positions and make sure you understand where they're coming from. So partners really rely on the law firm to fill positions for them. And so they rely on the recruiting coordinator or recruiting staff to do that for them. And they typically do not have a lot of authority to hire on them. So many times just applying to a partner is not going to really get you very far unless that partner has a lot of business and so forth. But I would recommend just applying to the law firms that you like. Many times can be helpful, meaning sending your resume through the portal or via email. Now, another thing that's very helpful, so you have to remember all these people are very busy, and the recruiting personnel inside of law firms are very busy. But if you call many times, they will talk. And again, I'm upsetting a lot of recruiting people saying this, but if you call law firms and you call the recruiting department and say, I'm a student at this law school and I really like your firm, I'd like to apply, that can be very helpful. And you can often get positions that way. And then ask them follow up and say, do you think you're going to have jobs? Do you think you're having any openings? Will you keep my resume in file? Connect with the person on LinkedIn, follow up, and so forth. The other thing that's often very important, can help quite a bit, is sending a written resume. So sending a letter like written. The reason sending a written letter, with resume is helpful is because when you email and you just apply on portals and so forth, what happens is your resume just goes into someone's inbox and is never seen again. But if you send a written letter many times, then that sits in someone's desk. They see it, and then it reminds them that you've applied. So that can be extremely helpful. And people do like to see written letters. One of the secrets is that at BCG, for example, we always send written letters and often faxes to law firms, and that helps our response rate quite a bit. And people will respond through our applications a lot easier. Okay, next question. I worked in a medium-sized firm for 2 years after a state clerkship. I had to do medical leave for 2 years, non-secretarial questions on how to approach the job search and gaps in my resume. The first thing is, that's great. You worked for 3 years. If you did have to take a medical leave, if you're a woman, many times people will assume that you had kids and want to go back to work. If you're a man, you may have to bring up that leave of absence, but it is a good market right now. So what I would recommend doing is applying to as many places as you can. Hopefully you can apply to both law firms and then places in other practice settings. I would apply to openings, and I would also apply to places that don't have openings and not openings. One of the things that I think is very useful for you to do wherever market you're in is to always research and look at Google and things like that to see firms that may be in different areas you'd be interested in. Applying to as many geographic areas as you possibly can is always important. I've done like searches before for firms. I'm just thinking right now in Hawaii, and they've had an impossible time attracting applicants, which which would seem very unusual when these law firms are like right on beaches and so forth. So you really want to make sure that when you're applying to positions, that you're always applying to as many geographic regions and places as possible. You want to make sure that, especially with your bar, and when you're trying to get back to work, applying to a range of firms is often important. And then just because you were out for 2 years, it's generally not a good idea to leave, but when you get into interviews and if people see you and like you, they're more likely to hire you than if you talk about a medical leave of absence right when you're in the interview, right when you're in your resume. So I wouldn't bring it up really. And again, if you're a woman, they're just going to assume you've had kids. Usually, I mean, I'm not saying that that's sexist or not sexist, but that's what they will think. And if you're just applying for jobs, you can do it that way. But I would also apply just to firm. The other thing you can do too is if you have a pleasing personality, then you'll do well in interviews, and it sounds like you may, if you're able to get these jobs. The other thing you can often do is just some of the suggestions that I've made on this webinar so far, which is not email, many times showing up or hand delivering application. It's a local law firm. I've hired a bunch of people. I used to have an office in downtown Malibu, like there was just like a big center there. And every so often people would walk in and hand deliver their resume. And I can remember everyone that's ever done that because it was a person like once every 6 months or something. And their odds of getting hired were very good. I used to be in downtown Los Angeles and people would come in all the time and deliver resumes. And those people would get a lot of attention. These sorts of things are good if you need to stick out and you want people to see you. People like that. It's a good way to get hired. I would say writing people is another good way to get hired because things sit on their desk. Resumes, instead of sitting in their anything physical is good. But I don't think you're going to have too much of a trouble finding a position. But those are, things I would recommend. Okay, the next question is, how recent should your writing sample be? Also, if other people edited the writing sample, can I not use it? I'm an associate with 1 year's of experience. Your writing sample should show your best work. So your best work should be your most recent work, hopefully. So your most recent work should be your best work. So I always recommend your most recent work. If other people did edit the writing sample, it depends on how it was edited. You have to use your own judgment. Obviously, when a law firm's asking for a writing sample, they want to see your editing experience. If you do send something that someone else has edited, I don't know it just depends. You have to use your own judgment on that. But I would recommend doing something that you only edited and doing that. So that's the right thing to do. Most people would probably turn in something that other people have looked at. I think that what they're really trying to see is how careful you are, how, good your stuff looks and so forth. And is it wrong to have someone edit your college application? I certainly probably would have been better off if I had someone edit my essays and so forth when I was in college and law school and so forth. So you just have to kind of use your own judgment. What type of sample should a government attorney use? All my work is collaborative or privileged. You should have something that you did. And if they do ask you for that, then tell them that, but say I have something from law school and so forth, and then go back and edit whatever you did in law school. So you should have something that you've written. But if it's all collaborative or privileged, you can tell them that or when you turn it in, but you can't certainly turn in something privileged. But if not, I would use from law school or from when you were practicing if you did before you went to practice. Let's see here. These are great questions, by the way. Thank you, everyone who's asking. On your point about working the best law firm early in your career, coming out of a top school but not working in a big firm, I'm always playing catch up with my peers who started. And boy, I always be playing catch up. Will I always be lagging behind in the writing skill because it didn't start off at one of these major firms? No, absolutely not at all. So the idea is that large law firms typically have certain standards, which is why they can charge more. Those standards are for things like quality. Does that mean they always have the best work? No. But law firms typically have the largest standards. The smaller the firm, less standards. So the law firms will have certain standards in terms of the type of people to hire, the work quality, the logic, what's acceptable, what's not, how many people, what it takes to succeed. It's harder to succeed there, so you have to do better work. Or they're working for larger clients, they have higher expectations. Now, none of this means that you can't be a really good attorney if you work in a smaller firm. That's just ridiculous. But what it does mean is that you have to learn and have very high standards for yourself and really take this stuff and the pride in your work and type of work you do very seriously. But typically, one of the reasons that, and this is actually a very important thing to understand, one of the reasons people take law school to go seriously, et cetera, seriously in the legal profession is, and again, I'm not trying to be mean to anyone here, and I don't, because certainly I didn't go to the number 5 law school in the country, but is being a lawyer in many senses is a game of smarts. So, a good litigator will outthink an average litigator. A good corporate attorney will outdeal and outthink and so many times that those thinking processes, I believe, can be developed. I believe it doesn't matter where you went to law school. It doesn't matter if you develop all this, but it's a game of smarts and logic and all that sort of thing. So and again, I hate saying this stuff, but because it's not nice and it's almost not American, but because everyone tries to be equal. But I've hired attorneys before, and I hired an attorney once that graduated from Berkeley Law School, literally at the age of 19. And he'd also got into Harvard Law School, but he went to Berkeley because he wanted to get away from the East Coast of his parents. This guy, he got a Wayne or LSATs or whatever the grade is, but he went up once against, I had this very complex case where the former head of the Labor and Employment Department, Quinn Emanuel, was our co-counsel. And this guy took one look at it and figured out a solution after hundreds of thousands of dollars of litigation in like 15 minutes. Just beautiful, logical solution to the problem that I never would have seen. And certainly this other person didn't see. So sometimes, and this guy was hired, he was recommended by someone that I knew because he couldn't find a job when he was so young. But this guy is just incredible. So a lot of times, very smart people are able to figure out logical things and do things in a way that others can't. You can certainly learn it, but not just because he was smart, he didn't end up practicing law and was very upset that he didn't get a job in a large law firm. Eventually went off the rails. But the point is that very smart people have skills many times that you don't. And a lot of it, when they are practicing, comes down to their work quality. It comes down to how thorough they look at things. It comes down to the type of work they turn in. So typically the larger firms will turn in very well reasoned and proofed and good looking work. And if you're in a court, if you're like a court clerk, you can always see this. The best firms are the most thorough, and every little detail is looked at closely, whereas the average firms aren't. And it works against, and you can trust their work and you can trust their logic more. So this is just the thing with large law firms. So your goal as an attorney is to bring those standards of things. So not all large law firms have the best quality work and so forth, but for the most part, it's more trusted. And just as you're more likely to have a good meal at a lot of chain restaurants than you would just a local restaurant that you may not know the standards for. So this is why the large law firms can charge more. It's why certain chains can charge more than a local restaurant. It's because of the standards that they have. So this is what you learn many times with law firms. Then there's nothing to say that you can't bring those standards to wherever you work, but you need to have constantly improving work. Now, the only other thing I would say about the smaller law firms is many times their clients are smaller and unwilling to pay for very careful work. So an example would be, if I'm in a large law firm, I can spend 10 hours or say 20 hours researching and writing the memo, and then another 15 or another 30 hours proofing it, tidying up the language. I'm in a smaller firm. I may have 10 hours, do the motion, and then no research. And for a memo, we're going to wing it. And that's just typically what happens. So you learn these sorts of things. So this is the difference between a large law firm and a smaller law firm. So the larger law firm is just going much more slowly through things because they have the time. And that's why the partners make more money. That's why they have larger clients. And these are just all that are important for an attorney to understand. So, that when the conclusions are reached by a larger law firm, they're much more likely to be correct than what a smaller law firm is doing. That's the point. And then when you learn to think that way, you become a much better attorney many times in the law firm. And again, I hate to say all that stuff because it's not very nice, but it's just what it is. I certainly didn't get a 180 rights also. So I'm just saying that certain people have very good legal skills, and a lot of times it's natural. And all these things too, in terms of this logic and the ways of thinking through things, can be learned. And so I think that you would be surprised if most attorneys, if they went back and took the LSAT 10 years later, would probably do much better than they did originally, because you learn all this kind of logic skills and stuff as you do it. especially if you work with good attorneys. And again, remember, you become like the people you spend your time with. And when interfering with state all collection area the client will on appeal for your unique strategy of submitting $0 for proceedings bond. I want to include the bond or related motion, but I just noticed one spell word in the motion. It's better to use a winning bond in motion. I think if you have one misspelled word, I don't think that's going to be the end of the world. I think that if it's a really good motion, you could also just black out a section of it if you want, if it's what's confidential or something. But I think that's great. I think you can include it as long as it sounds like you did a good job. So I wouldn't worry about that. Earlier, you said that, okay, there's another question, that illegal writing doesn't miss issues. How do you reconcile the rights to one of the three issues and ignoring the rest? The idea of not missing issues, this would be that this is just good litigation. It doesn't miss issues. Just if there's a major issue that you miss that could change the direction of an issue that you're analyzing, you need to make sure you have it in there. I think you guys know what I mean by that. Too much time on that. Okay. Okay. Can I use a memo that I wrote for a judge, even though the case is still pending? I would think so. If it's just about a legal issue and you don't mention the client's name, I think I don't think anyone, especially if it's not involving anybody, then I think you're probably okay. Okay. I think that's all the questions. I certainly appreciate everyone staying for all these questions today. These were great questions. And again, we're back next week and take questions. But next week's also exciting because we're going to do the state of the market, which is an annual thing where we'll go over and tell you guys where all the opportunities are and all the geographic areas where there's a lot of stuff going on as well. So thank you. And I will talk to everyone next week. Thanks.